colonial government designated the 4th of July, a date profoundly dear and symbolic to the United States and its people, the Americans, as the official end of the insurrection of their newly acquired possession, which is our country, the Philippines. This insurrection, such by the US government, was recognized by the Filipino revolutionaries as a legitimate war. The legitimate war began in February 1899 during the San Juan Bridge and ended in March 1901 with the surrender of President Emilio Aguinaldo. His surrender to the new colonizers who had been portraying themselves as benevolent people and friends to the natives led to the surrender of the revolutionary forces across the archipelago. However, the Filipino resistance in different areas, such as in southern Luzon and Mindanao, continued to threaten the American rule in the Philippines until the year 1913. Battle of Badbagsak, it is one of the last skirmishes during the period. It was a fight between the forces of Dato Amil of Sulu and General John Pershing of the United States Army. In early 1899, US President William McKinley sent to the Philippines a mission tasked specifically to assess the Philippine situation and establish a civil government in the islands. The first Philippine Commission was headed by Jacob Scorman, then president of Ivy League school, Cornell University, together with George Dewey, Elwell Otis, Charles Denby, and Dean Worcester. The commission gave some key recommendations to the US presidents on how to proceed with the establishment of colonial rule in the Philippines. First, it suggested that a civil government should supplant the existing military administration, established in August 1898 after the American victory in the mock Battle of Manila, and first headed by General Wellesley Merritt. Second, it recommended the creation of bicameral legislature with the lower house to be composed of the Filipino statement, while leaving the upper house to the American colonial administrators. Lastly, the Scorman Commission likewise endorsed the improvement of the general sanitary condition of the Philippines and founding a public school system to educate the Filipinos. The Second Philippine Commission was led by William Howard Taft and was sent to the Philippines in June 1990. The Second Philippine Commission, also known as the Taft Commission, proceeded to execute the recommendations previously given by Scorman and his colleagues. On October 1990, the Philippine Commission was given the authority to exercise legislative powers in the Philippines by President William McKinley. On July 4, 1901, a civil government was established known as the Insular Government with Taft himself as the Governor General. A military governor, Adna Chaffee, continued to administer unpacified areas until exactly a year later when the Philippine insurrection was declared officially over. After the establishment of a civil government in islands with William Howard Taft, colony originally composed of Dean Worcester, Luke Edward Wright, Henry Clay Ide, and Taft himself, passed a number of legislations which aimed to further the American colonial agenda, to prevent any imminent resistance from the Filipinos, and to avoid the Americans being portrayed to the public negatively. One of these was the Philippine Commission Act number 277, also known as the Libel Law of 1901. This particular law, enacted in October of the said year, prohibited malicious defamation in writing, printing, and theatrical exhibitions. The primary source is the Act number 277 itself, which was published on October 24, 1901. It is an act defining the law of libel and threats to publish a libel, making libel and threats to publish a libel misdemeanors, giving a right of civil action, therefore, and making obscene or indecent publications misdemeanors. So, by authority of the President of the United States, be it enacted by the United States Philippines Commission, that the first section, it is stated that a libel is a malicious defamation expressed either in writing, printing, or signs or pictures or the like, or public theatrical exhibitions, tending to blacken the memory of one who is dead, or to impeach the honesty, virtue, or reputation, or publish the alleged or natural defects of one who is alive, and thereby expose him to public hatred, contempt, or ridicule. In Section 2, every person who willfully and with a malicious intent to injure another publishes or procures to be published any libel shall be punished by a fine or not exceeding $2,000 or imprisonment for not exceeding 1 year or both. Section 3. An injurious publication is presumed to have been malicious if not justifiable motive for making it shown. In Section 4, in all criminal prosecutions for libel, that truth may be given the evidence to the court, and if it appears to the court that the matter charged as libelous is true and was published with good motives, and for justifiable ends, the party shall be acquitted. Otherwise, lie shall be convicted, but to establish this defense, not only must the truth of the matter so charged be proven, but also that it was published with good motives and for justifiable ends. In Section 5, to sustain a charge of publishing a libel, it is not needful that words or things complained of should have been read or seen by another. It is enough that accused knowingly parted with the immediate custody of the libel under circumstances which expose it to be read or seen by any other person than himself. In Section 6, every author, editor, proprietor of any book, newspaper, or serial publication is chargeable with the publication of any words contained in any part of such book or number of each newspaper or serial as fully as if he were the author of the same. In Section 7, no reporter, editor, proprietor, or any newspaper is liable to any prosecution for a friar and true report of any judicial, legislative, or other public official proceedings, or of any statement, speech, argument, or debate in the course of the same, except upon proof of malice in making such report, which shall not be implied from the mere fact of publication. In Section 8, libelous remarks or comments connected with matter privilege by the last section receive no privilege by reason of being so connected. In Section 9, a private communication made by any person to another in good faith in the performance of any duty, whether legal, moral, or social, solely with the fair and reasonable purpose of protecting the interests of the person making the communication or the interest of the person to whom the communication is made, is a privileged communication, and the person making the same shall not be guilty of libel, nor be within provision of this act. Every person, in Section 10, every person who threatens another to publish a libel concerning him, or any parent, husband, wife, or child such person, or any member of his family, and every person who offers to prevent the publication of any libel upon another person with intent to extort any money or other valuable consideration from any person shall be punished by a fine not exceeding $1,000 or by imprisonment for not exceeding 6 months or both. In Section 11, in addition to the criminal action hereby prescribed, a right of civil action is also hereby given to any person liable, as herein before, as forth against the person libeling him for damages sustained by such libel, and the person so liable shall lie entitled to recover in such civil action not only to the actual pecuniary damages sustained by him, but also damages for injury to his feelings and reputation, and in addition, such punitive damages as the court may think will be a punishment to the libeler and an example to others. Suit may be brought in any court of first instance, having jurisdiction of the parties. The presumptions, rules of evidence, and special defenses provided for criminal prosecutions shall be equally applicable in civil actions under this section. In Section 12, any person who writes, composes, stereotypes, prints, publishes, sells, or keeps for sale, distributes, or exhibits any obscene or indecent writing, paper, book, or other matter, or who designs, copies, draws, engraves, paints, or otherwise prepares any obscene picture or print, or who molds, cuts, casts, or otherwise makes any obscene or indecent figure by such writing paper, book, print, or figure shall be guilty of a misdemeanor and punished by a fine of not exceeding $1,000 or by imprisonment not exceeding 1 year or both. In Section 13, all laws and part of laws now in force so far as the same may be in conflict herewith are hereby replaced, provided that nothing herein contained shall operate as a repeal of existing laws, in so far as they are applicable to pending actions or existing causes of action. But as to such causes of action or pending actions, existing laws shall remain in full force or effect. In Section 14, all criminal actions under the provisions of this Act shall be begun and prosecuted under the sole direction and control of the ordinary prosecuting officers, anything in the existing laws to the contrary notwithstanding. In Section 15, which is the last section, this Act shall take effect on its passage.
El Renacimiento, or also known as Avis de Rapina. It is one of the most notable incidents which involved the law discussed above that took place in 1908. It was when Dean Worcester and the Secretary of the Interior filed a complaint against El Renacimiento, a newspaper company established by Rafael Palma in 1901. Worcester, a Michigan-trained zoologist and a colonial administrator, was offended by the editorial article on October 30, 1908. The piece entitled Avis de Rapina, or Bird of Prey, was written by Fidel Reyes. However, the case filed by Worcester likewise implicated a number of key figures running and contributing to the newspaper, such as Martin Ocampo, Teodoro M. Calao, Lope K. Santos, and Faustino Aguilar. The newspaper exposed Worcester to public hatred, contempt, and ridicule. They write, print, edit, publish, and circulate in a regular daily issue of the newspaper, which contains a certain false, injurious, and malicious defamation and libel that impeach the honesty, virtue, and reputation of the dean. In 1912 decision, the Supreme Court found the defendants guilty and sentenced them to fines and prison terms. Nonetheless, no prison time was rendered by any of them, as the Governor General Francis Button Harrison later on provided executing pardon.
So another legislation intending to suppress Filipino nationalism was likewise enacted with the Philippine Commission in November 1901. The Philippine Commission Act No. 292, or also known as the Sedition Law of 1901, which prohibited the Filipino from advocating Philippine independence or the political separation from the United States, covering all possible methods from the over to the passive, including speeches, publication, and literature. Those found guilty of sedition were sentenced to death or imprisonment. By authority of the President of the United States, be it enacted by the United States Philippine Commission that Section 1. Every person from the Philippines who charges war against them or adheres to their enemies, giving them aid and comfort within the Philippine island or elsewhere, is guilty of treason and will suffer death or at the discretion of the court shall be imprisoned at hard labor for not less than 5 years and line not less than $10,000. Section 2. Every person knowing any treason against them who conceals, disclose, and make known the same to the provincial governor in the province in which he resides, or to the civil governor of the island, or to some judge of a court of record is guilty of misprision of treason and shall be imprisoned not more than 7 years and be fined not more than $1,000. Section 3. Every person who incites, sets on foot, assets, or engage in any rebellion or insurrection against the authority of the United States or of the government of the Philippine Island be imprisoned for not more than 10 years and he fined not more than $10,000. Section 4. If two or more persons conspire to overthrow, put down, or destroy by force the government of the United States in the Philippines Island or the government of the Philippine Island, each of such persons shall be punished by a fine of not more than $5,000 and by imprisonment with or without hard labor for a period not more than 6 years. Section 5. All persons who rise publicly to attain by force or outside of legal methods any of the following objects are guilty of sedition. First, to prevent the promulgation or execution of any law or the free holding of any popular election. Second, to prevent any provincial or municipal government or any public official from freely exercising duties or the due execution of any judicial or administrative order. Third, to inflict any act of hate or revenge upon the person or property of any official or agent of the insular government, provincial or municipal government. Next, to inflict with the political or social object any act of hate or revenge upon individuals or upon any class of individuals in the island. And lastly, to despoil the political or social object any class of persons, natural or artificial, a municipality, a province, or the insular government, or the government of the United States, or any part of its property. Section 6. Any person guilty of sedition as defined in Section 5 hereof shall be punished by a fine of not exceeding $5,000 or by imprisonment not exceeding 10,000 or both. Section 7. All persons conspiring to commit the crime of sedition shall be punished by a fine of not exceeding $1,000 or by imprisonment not exceeding 5 years or both. Section 8. Every person who shall utter seditious words or speeches, write, publish, or circulate libels against the government of the United States shall be punished by a fine not exceeding $2,000 or by imprisonment not exceeding 2 years or both in the discretion of the court. Section 9. All the persons who form any secret society or who shall, after the passage of this act, shall be punished by a fine not exceeding $1,000 or by imprisonment not exceeding 1 year or both. Section 10. When a state of war or insurrection against the authority or sovereignty of the United States no longer exists in the Philippine Island, it shall be unlawful for any person to advocate orally or by writing the independence of the Philippine Island or their separation from the United States, whether by peaceable or forcible means. Violating of this section shall be punished by a fine of not exceeding $2,000 and imprisonment not exceeding 1 year. Section 11. Every person who shall administer or be present in consent to the administering of any oath or any engagement purporting to the bind of the person taking the same to commit any crime punishable by death or by imprisonment for 5 years or more shall be punished by a fine not exceeding $2,000 or by the imprisonment not exceeding 10 years. Section 12. Any person who administers or who is present and the consenting to the administering of any oath or engagement purporting to the bind of the person taking the same to engage in any seditious purpose to disturb the public peace or commit or endeavor to commit any criminal offense, to fail or refuse to inform and give evidence against any associate, confederate, or other person, to fail or refuse to reveal or discover any unlawful combination, any illegal act done or to be done, or any illegal oath or obligation or the import of any such oath, and who attempts to induce any person to take any such oath or engagement and shall be punished by a fine not exceeding $1,000 or by imprisonment not exceeding 5 or both. Section 13. Any person who under such compulsion as would otherwise excuse him offense against either of the last two preceding sections shall not be excused thereby unless within the periods herein after stated he declares the same and the person by whom such oath or engagement was taken. Such declaration may be made by him within 14 days after the commission of the offense, or if he hindered from making it by actual force or sickness, then within 8 days after cessation of such hindrance or in his trial, that happens before the expiration of either of those periods. Section 14. Any person who shall have taken any oath before any military officer or any officer under the civil government of the Philippine Island, after the passage of this act, violate the terms and provisions of such oath or any such term shall be punished by a fine not exceeding $2,000 or by imprisonment not exceeding 10 years or both. Section 15. This act shall not apply to the organized provinces of Batangas, Cebu, and Bohol, or nor to any province where civil government has not been established. Section 16. All laws and parts of laws now in force that nothing herein contained shall operate as a repeal of existing laws in so far as they are applicable to pending actions or existing causes of action, but as to such causes of actions or pending action, existing law shall remain in full force and effect, this act being entirely prospective. Section 7. A foreigner residing the Philippine Island who shall commit any of the crimes specified in the preceding section of this act, except those specified in Section 1 and 2, shall be punished in the same way and with the same penalty as the prescribed for the particular crime therein.
Hi, my name is Sasam Chloe Marie C. and I will be discussing Act Number 1696 or the Flag Law of 1907 and Act Number 518 or the Brigandage Law of 1902. In Act Number 1696 or the Flag Law of 1907, it is a legislation enacted on August 23, 1907 by the All-American Philippine Commission in which displaying of flags, banners, and emblems are prohibited which may entice Filipinos to rebel against the United States. This law included the symbols used by the society in which it initiated the Philippine Revolution in 1896, the Katipunan. In this law, it is unlawful for any person to display flags or symbols in any event. A punishment of fine not less than 500 pesos nor more than 5,000 pesos and an imprisonment of not less than 3 months or not more than 5 years. Act Number 518 or the Brigandage Law of 1902 is another legislation enacted on November 12, 1902 by the American authorities which prohibited the act of highway robberies or brigandage in the Philippines. Whenever 3 or more persons form a group to steal personal properties by means of violence and force and shall go out upon the highway and roam over the country armed with deadly weapons for the purpose of robbery shall be considered as robbers or brigands, therefore shall be punished by death or imprisonment not less than 20 years. To prove the crime, it shall not be necessary to adduce evidence, but as long as the person is part of the group or is accused as member shall be punished. Anyone who is known as aiding or assisting in such brigands like giving information of the movement of the police or securing stolen properties like food supplies, clothing, arms, and ammunition shall also be punished by imprisonment of not less than 10 years and not more than 20 years.
Hi Miss, so I will be discussing about the excerpts of the Philippine Organic 1902. So, the Philippine Organic was a basic law for the insular government that was enacted by the US Congress on July 1, 1902. Gitawag po ni siya as Philippine Bill of 1902 and the Copper Act nga gipangunahan ni Henry A. Cooper the approval of the act coincided with the official end of the Philippine-American War. So let me tell you a little overview about my topic. So the Philippine Organic Act provided for the creation of an elected Philippine Assembly after the following conditions were met. Una, the cessation of the existing insurrection in the Philippine Islands. Ikaduha, completion and publication of a census. Ikatulo, 2 years of continued peace and recognition of the authority of the United States of America after the publication of the census. Lastly, after the convening of the Assembly, legislative power shall then be vested in a bicameral legislature composed of the Philippine Commission as the upper house and the Philippine Assembly as the lower house. Supervision of the islands was assigned to the War Department's Bureau of Insular Affairs. So, I have here mga key provisions nga included sa akong topic. So the first one is a Bill of Rights for the Filipinos. The appointment of 2 Filipino non-voting president commissioners to represent the Philippines in the United States Congress. Ikatulo, this establishment of the Roman Catholic Church. Kaupat, conservation of natural resources for the Filipinos. Ikalima, exercise of executive power by the civil government who would have several executive departments. Ikaanom, establishment of the Philippine Assembly to be elected by the Filipinos 2 years after the publication of a census and only after peace and had been restored completely in the country. So in general, mas pasabot dito nga ang Filipinos have the right to choose kung unsay sakto para sa ilahang kaugalingon o para sa ilang katawhan o para sa lugar. So I have here a little background about my topic. So the act was preceded by the Spooner Amendment to the Army Appropriation Act of 1901, enacted 2 March 1901, which had provided that all military, civil, and judicial powers necessary to govern the Philippines island shall until otherwise provided by Congress be vested in such person and persons, and shall be exercised in such manner as the President of the United States shall direct for the establishment of civil and government, and for maintaining and protecting the inhabitants of said islands in the free enjoyment of their liberty, property, and religion. So, meaning to say, mas importante ang president or dapat na ay president sa usa ka nation kay to protect o i-maintain ang security para sa katawhan, para i-manage po ang dapat buhaton o ma-create or to improve their economy. So, this was completed by a cable from the Secretary of War Elihurut to the Philippine Commission on March 5, 1901. Until further orders, the government will continue under existing instructions and orders. The comprehensive Spooner Amendment and these instructions and orders virtually constituted for many months the character of government for the Philippine Islands between September 1900 and August 1902. The Second Philippine Commission, or gitawag nilang the Taft Commission, issued 499 laws. So for the implementation of this topic, the act was enacted into law. So natawag siya law on July 1, 1902, and the Philippine Commission executed its provision. A census was conducted in 1903, nga gipublish siya on March 25, 1905. The Philippine Assembly elections of 1907 were held on July 30, 1907 for 80 seats, and on October 16, 1907, the first Philippine legislature was inaugurated at the Manila Grand Opera House. So, in general, or the result, of this act, the Catholic Church agreed to gradually substitute Spanish priests with Filipinos and to sell its land. It refused, however, to send the friars immediately back to Spain. In 1904, the American administration bought 166,000 hectares, a major part of the friars holding over half of which was in the Manila area, and the land was resold to Filipinos. Some of them tenants, but the majority of them state owners. So this time mas na freedom ang Filipinos kay na-push man nila nga ilisa nila ang Spanish nga priest sa Filipino nga priest. Nga dito nag-start pod nga ang mga Pinoy is na sila freedom, naka-start na sila nga to mag-rebuild o para to have their own freedom sad nga dili na sila maglibog sa pamalakad na sa mga banyaga during that time. And that would be all. Thank you.
Section 9 is all about the public property and public legislation and public domain, while Section 12 talks about the Philippine legislature. It is stated in Section 12 that general legislative powers in the Philippines shall be vested in a legislature which consists of two houses. First house is for the Senate, and other for the House of Representatives. The two houses shall be designated as the Philippine legislature. In Section 13, hereby we talk about the election and the qualification of the senators. Whom to elect and how to elect. What are the qualifications of a person in order to be a senator? It is stated there that the member of the Senate of the Philippines shall be elected for terms of 6 and 3 years, and provided that they are qualified electors of the Philippines. Section 14, on the other hand, is for the second house, for the election and qualification of the representatives. It is stated here that members of the House of Representatives shall be elected perennially by the qualified electors of the Philippines. Each of the representative district provided for shall have the right to elect one representative. No person shall be an elective member of the House of the Representative who is not a qualified elector and over 25 years of age, and who is not able to read and write either the Spanish or the English language. Those who has not been an actual resident of the district from which elected for at least 1 year immediately prior to his election is also not allowed. So, who will elect for the senators and the representatives? That is what Section 15 is all about. Section 15 tackles about the qualification of a voter. It is stated that the first election held pursuant to this act, the qualified electors shall be those having the qualifications of voters under the present law. Branches. First is the election and tenure, that the first meeting of the Philippine legislature created by this act and triennially thereafter there shall be chosen by the legislature two resident commissioners. Last branches. First is the selection and tenure, that the first meeting of the Philippine legislature created by this act and triennially thereafter there shall be chosen by the legislature of two resident commissioners. Lastly, the compensation. Each of said resident commissioners shall, in addition to the salary and the sum in lieu of millage now allowed by the law, be allowed the same sum for stationery and for the pay of necessary clerk.
So moving on to Section 21 of the Philippine Autonomy Act of 1916. This section defined the title, appointment, residence, power, and duty of the Governor-General of the Philippine Islands. The supreme executive power is vested to the Governor-General of the Philippine Islands. The Governor-General shall be appointed by the U.S. President and with advice and consent of the U.S. Senate. The Governor-General shall reside in a country and hold his office at the pleasure of the U.S. President. The Governor-General can appoint members and officers of his cabinet with the consent of the Philippine Senate. The Governor-General shall have general supervision and control of all departments and bureaus of the government of the Philippines, including the control of locally created armed forces and militia. The Governor-General shall be responsible for the execution of laws in the Philippines, preserve peace, and protect the Philippines from enemies, foreign or domestic. The Governor-General has the power to grant pardons, reprieves, remit fines, and may veto any legislation enacted by the Philippine legislature. Moving on to Section 22 of the Philippine Autonomy Act. This section defined the process of peaceful transition of departments, checks and balances between the executive and legislative departments, and provisions for the Bureau of Non-Christian Tribes. The legislation shall seize and determine if the heads of executive departments are qualified to hold their office or not. The legislative department has the power to remove heads of these executive departments and approve or deny appointments made by the Governor General. The Bureau of Non-Christian Tribes is also established and has general supervision over public affairs of the inhabitants of the territory represented by the legislature by appointive senators and representatives. Moving on to Section 26, Judiciary. Section 26 defines the jurisdiction of courts and appointment of judges. The Supreme Court of the Philippine Islands shall possess and exercise jurisdiction of all actions, cases, causes, and proceedings as prescribed by law. The Chief Justice and Associate Justices of the Supreme Court shall be appointed by the U.S. President and with the advice and consent of the U.S. Senate. Municipal courts of the said islands shall possess and exercise jurisdiction as now provided by law. These judges of these courts shall be appointed by the Governor General and with the advice and consent of the Philippine Senate. Moving on to Section 27. Section 27 describes or states that the Supreme Court of the United States shall have jurisdiction to review, revise, modify, or affirm the final judgments and decrees of the Supreme Court of the Philippine Islands in all actions, cases, causes, and proceedings which the Constitution or any statute, treaty, title, right, or privilege of the United States is involved, or in causes in which the value in controversy exceeded $25,000, or in which the title or possession of a real estate exceeds the sum of $25,000. So moving on to the Philippine Independence Act of 1934. The Philippine Independence Act, also known as Tidings-McDuffie Act of 1934. This is a U.S. statute that provides independence to the Philippines to take effect on July 4, 1946, after a 10-year transition period of the government of the Commonwealth of the Philippines. The bill was signed by U.S. President Franklin D. Roosevelt on March 24, 1934. For the next 10 years, the Philippines will remain a U.S. territory. Foreign affairs, defense, and monetary matters remain under U.S. jurisdiction, but all other internal matters were in the hands of the Filipino people. Section 1 of this act allows the Philippine legislature to formulate and draft a constitution for the government of the Commonwealth of the Philippine Islands. This constitution shall exercise jurisdiction over the Philippine territory ceded to the United States by the peace treaty concluded between the United States and Spain on the 10th of December 1898. They are referring to the Treaty of Paris. Section 2 of this law mandates the Constitution that is formulated and drafted shall be in a republican in form and shall contain the Bill of Rights and other provisions. These provisions describe the relationship between the U.S. and the Commonwealth Government of the Philippine Islands. The implementation of this provision shall end pending the final and complete withdrawal of sovereignty of the United States over the Philippine Islands. Section 6 of this law describes the trade relations between the United States and the Commonwealth Government of the Philippine Islands. No? The law describes the rate of import and export tax to be imposed during the 10-year transition period. Thank you.
Of the Philippine Islands, there shall be held a conference of representatives of the Government of the United States and the Government of the Commonwealth of the Philippine Islands, such representatives to be appointed by the President of the United States and the Chief Executive of the Commonwealth of the Philippine Islands, respectively, for the purpose of formulating recommendations as to future trade relations between the Government of the United States and the independent government of the Philippine Islands. The time, place, and manner of holding such conference to be documented by the President of the United States, but nothing in this proviso should be construed to modify or affect in any way any provision of this act relating to the procedure leading up to the Philippine independence or the date upon which the Philippine Islands shall become independent. Section 7. Until the final and complete withdrawal of American sovereignty over the Philippine Islands. 1. Every duly adopted amendment to the Constitution of the Government of the Commonwealth of the Philippine Islands shall be submitted to the President of the United States for approval. If the President approves of the amendment or the President fails to disapprove such amendment within 6 months of the time of its submission, the amendment shall take effect as part of such Constitution. 2. The President of the United States shall have an authority to suspend the taking effect of the operation of the law, contract, or executive order of the Government of the Commonwealth of the Philippine Islands, which in his judgment will result in a failure of the Government of the Commonwealth of the Philippine Islands to fulfill its contract. 3. The Chief Executive of the Commonwealth of the Philippine Islands shall make an annual report to the President and Congress of the United States of the proceedings and operation of the Government of the Commonwealth of the Philippine Islands, and shall make such other reports as the President or Congress may request. 4. The President shall appoint by and with the advice of and consent of the Senate a United States High Commissioner to the Government of the Commonwealth of the Philippine Islands, who shall hold office at the pleasure of the President and until his successor is appointed and qualified. He shall be known as the United States High Commissioner to the Philippine Islands. He shall be the representative of the President of the United States on the Philippine Islands and shall be recognized as such by the Government of the Commonwealth of the Philippine Islands, by the commanding officer of the military forces of the United States, and by all civil officials of the United States in the Philippine Islands. He shall have access to all record of the government or any subdivision thereof, and shall be furnished by the Chief Executive of the Commonwealth of the Philippine Islands with such information as he shall request. 5. The Government of the Commonwealth of the Philippine Islands shall provide for the selection of a President Commissioner to the United States, and shall fix his term of office. He shall be the representative of the Government of the Commonwealth of the Philippine Islands, and shall be entitled to official recognition as such by all departments upon presentation to the President and credentials signed by the Chief Executive of Government. He shall have a seat in the House of Representatives of the United States with the right of debate but without the right of voting. Section 8. Effective upon the acceptance of this act by concurrent resolution of the Philippine legislature or by a convention called for that purpose as provided in Section 17. 1. For the purposes of the Immigration Act of 1917, the Immigration Act of 1924 except Section 13C, this section and all other laws of the United States relating to the immigration, exclusion, or expulsion of alien citizens of the Philippine Islands who are not citizens of the United States shall be considered as if they were aliens. For such purposes, the Philippine Islands shall be considered as a separate country and shall have for each fiscal year a quota of 50. This paragraph shall not apply to a person coming or seeking to come to the territory of Hawaii who does not apply for and secure an immigration or passport visa, but such immigration shall be determined by the Department of the Interior on the basis of the needs of industries in the territory of Hawaii. 2. Citizens of the Philippine Islands who are not citizens of the United States shall not be admitted to the continental United States from the territory of Hawaii, whether entering such territory before or after the effective date of this section, unless they belong to a class declared to be non-immigrants by Section 3 of the Immigration Act of 1924 or to a class declared to be non-quota immigrants under the provision of Section 4 of such act other than subdivision C thereof, or unless they were admitted to such territory under an immigration visa. The Secretary of Labor shall be regulations provide a method for such exclusion and for the admissions of such expected classes. Tariff duties after independence. Section 13. After the Philippine Islands have become a free and independent nation, there shall be levied collection and paid upon all articles coming into the United States from the Philippine Islands. The rates of duty which are required to be levied, collected, and paid upon like articles imported from the foreign countries, provided that at least 1 year prior to the date fixed in this act for the independence. Immigration after independence. Section 14. Upon the final and complete withdrawal of American sovereignty over the Philippine Islands, the immigration laws of the United States shall apply to the person who were born in the Philippine Islands to the same case of other foreign countries.
So, moving on, we will be talking about the 1935 Philippine Constitution. One of the main provisions of the previously discussed Tidings-McDuffie Act was the organization of a convention that would draft and finalize the Constitution to be used by the Philippine government. In July 1934, Filipinos elected around 200 delegates for the said convention, with Senator Claro M. Recto of Tayabas as the head. The Constitution was finalized in February 1935 and was formally ratified through a plebiscite on May 14, 1935. The transitional government, called the Commonwealth, was eventually inaugurated in November of the same year with Quezon and Osmeña as President and Vice President, respectively. The Constitution, whether written or unwritten, is recognized as the supreme law of the land, as it serves as basis for the legitimacy of any governmental acts necessary for its existence. It is a codified law that determines the powers and duties of a government, where it also embodies certain rights of the people. So, the first article of the Constitution consists of the national territory of the Philippines. Basically, the Philippines comprises all the territories ceded to the United States by the Treaty of Paris concluded between the United States and Spain on December 10, 1898, which are limited to the Article 3 in the said treaty. So basically, this is the territory of the Philippines. After United States bought the Philippines for only $20 million to Spain. In Article 2 of the Constitution, it comprises of the Declaration of Principles. So the first section, the Philippines is a republican state. Sovereignty resides in the people and all government authority emanates from them. So this means that the Philippine government belongs to the public, which covers their interests and not from the officials. Section 2, the defense of the state is a prime duty of government, and in the fulfillment of this duty, all citizens may be required by law to render personal, military, or civil service. In times that the country is at stake, when a war emerges, its citizens may be used by the government to protect it, like the Singapore, wherein the law mandates that all their male citizens should undergo military training. Also in Korea, but in the Philippines, it is not strictly mandated. Next, in the Section 3 of the said article, the Philippines renounces war as an instrument of national policy, and adopts the generally accepted principles of international law as part of the law of the nation. So, as much as it emanates from our constitutional mandate to protect the country's national interest, our peaceful and legal response is also in keeping with our obligation as a responsible member of the community of nations. An example of which is our territory in the West Philippine Sea, which was claimed by China. It's not that we are afraid of them. It's just that the welfare of our nation would be at stake if we wage war. Instead of wasting resources, we should follow the law of our nation, which adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. Next is Section 4. The natural right and duty of parents in the rearing of the youth for civic efficiency should receive the aid and support of the government. Since the child is one of the most important assets of the nation, therefore every effort should be exerted to promote his welfare and enhance his opportunities for a useful and happy life. In Section 5 states that the promotion of social justice to ensure the well-being and economic security of all the people should be the concern of the state. This means that the maintenance of peace and order, the protection of life, liberty, and property, and promotion of the general welfare are essential for the enjoyment of all the citizens under the state. Next is the Article 3, which is the Bill of Rights. Section 1 states that no person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Next, private property shall not be taken for public use without just compensation. Next, the right of the people to be secure in their houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause to be determined by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. So this is very crucial because military men or policemen cannot enter your house or search if there is no warrant from the judge. So next is the liberty of abode and of changing the same within the limits prescribed by law shall not be impaired. The fifth section, the privacy of communication and correspondence shall be inviolable, except upon lawful order of the court or when public safety and order require otherwise. The next is the right to form associations or societies for purposes not contrary to law shall not be abridged. Next is no law shall be made respecting an establishment of religion or prohibiting the free exercise thereof, and the free exercise and enjoyment of the religious profession and worship without discrimination or preference shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. No law shall be passed abridging the freedom of speech or of the press or the right of the people peaceably to assemble and petition the government for redress of grievances. That's why UP people and any citizen can go about and protest if they felt that the government is unfair. Next is no law granting a title of nobility shall be enacted, and no person holding any office of profit or trust shall, without the consent of the National Assembly, accept any present, emolument, office, or title of any kind whatever from any foreign state. Next, no law impairing the obligation of contracts shall be passed. Next, no ex post facto law or bill of attainder shall be enacted. This states that a person can neither be punished for any offense which was at the time of commission not charged as an offense, nor be subjected to a penalty greater than that which might have been inflicted under the law in force at the time of the commission of the offense. Next, no person shall be imprisoned for debt or non-payment of a poll tax. No involuntary servitude in any form shall exist except as a punishment for crime whereof the party shall have been duly convicted. Next, the writ The privilege of the writ of habeas corpus shall not be suspended except in cases of invasion, insurrection, or rebellion, when the public safety requires it, in any of which events the same may be suspended, wherever during such period the necessity for such suspension shall exist. So, this means that the suspension clause protects liberty by protecting the privilege of the writ of habeas corpus. It provides that the federal government may not suspend this privilege except in extraordinary circumstances when a rebellion or invasion occurs and the public safety requires it. So, what is habeas corpus? Habeas corpus is a court order demanding that a public official, such as a warden, deliver an imprisoned individual to the court and show a valid reason for that person's detention. Next is that no person shall be held to answer for a criminal offense without the due process of law. Next is that all persons shall before conviction be bailable by sufficient sureties, except those charged with capital offenses when evidence of guilt is strong. Excessive bail shall not be required. In all criminal prosecutions, the accused shall be presumed to be innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witnesses in his behalf. Next, no person shall be compelled to be a witness against himself. Excessive fines shall not be imposed, nor cruel and unusual punishment inflicted. No person shall be twice put in jeopardy of punishment for the same offense. If an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Lastly, free access to the courts shall not be denied to any person by reason of poverty. That is why we have public attorneys, public prosecutors, public lawyers. So basically, Bill of Rights is what protects the people. So Article 4, Citizenship. Section 1, the following are citizens of the Philippines. Those who are citizens of the Philippine Islands at the time of the adoption of this Constitution. Those born in the Philippine Islands of foreign parents who, before the adoption of this Constitution, had been elected to public office in the Philippine Islands. Those whose fathers are citizens of the Philippines, those whose mothers are citizens of the Philippines and upon reaching the age of majority, elect Philippine citizenship. Those who are naturalized in accordance with law. And Section 2, Philippine citizenship may be lost or reacquired in the manner provided by law. Article 5 is suffrage. Section 1, suffrage may be exercised by male citizens of the Philippines, not otherwise disqualified by law, who are 21 years of age or over and are able to read and write, and who shall have resided in the Philippines for 1 year and in the municipality wherein they propose to vote for at least 6 months preceding the election. The National Assembly shall extend the right of suffrage to women, if in a plebiscite which shall be held for that purpose within 2 years after the adoption of this Constitution, not less than 300,000 women possessing the necessary qualifications shall vote affirmatively on the question. Okay, so lastly, in Article 6 is the Legislative Department. Section 1. The legislative power shall be vested in a National Assembly. The members of the National Assembly shall not exceed 120, shall be chosen every 3 years, and shall be apportioned among the several provinces as nearly as may be according to the number of their respective inhabitants. But each province shall have at least 1 member. The National Assembly shall by law make an appointment within 3 years after the return of every enumeration, and not otherwise. Until such appointment shall have been made, the National Assembly shall consist of 98 members, of whom 87 shall be elected by the representative districts as now provided by law, and 3 by the Mountain Province, and 1 by which of the other 8 existing special provinces. The members of the National Assembly in the provinces of Sulu, Lanao, and Cotabato shall be chosen as may be determined by law. In all other provinces shall be elected by the qualified voters therein. Section 2 states that no person shall be a member of the National Assembly unless he has been 5 years a citizen of the Philippines, is at least 30 years of age, and at the time of his election a qualified elector, and a resident of the province in which he is chosen for not less than 1 year immediately prior to his election. Next is Section 3. In case of vacancy in the National Assembly, a special election may be called in a corresponding district in the manner prescribed by law, but the member thus elected shall serve only for the unexpired term. Next, elections for the National Assembly shall be held on the dates fixed by law. The National Assembly shall convene in regular session once every year on the second Monday of the month, immediately following that on which the election of its members was held, unless a different date is fixed by law. The National Assembly may be called in special session at any time by the President to consider general legislation or only such subjects as he may designate. No special session shall continue longer than 30 days, and no regular session longer than 100 days exclusive of Sundays. Next, the National Assembly shall choose its Speaker, a Secretary, a Sergeant-at-Arms, and such other officers as may be required. A majority of all the members shall constitute a quorum to do business, but a smaller number may adjourn from day to day, and may compel the attendance of absent members in such manner and under such penalties as the National Assembly may provide. Next is that the National Assembly may determine the rules of its proceedings, punish its members for disorderly behavior, and with the concurrence of 2/3 expel a member. It shall keep a journal of its proceedings, and from time to time publish the same, expecting such parts as may in its judgment require secrecy. And in the yes and nays on any question shall at the request of 1/5 of its members present be entered in the journal. Salient features of the 1935 Constitution include the following: a bicameral legislature composed of a Senate and House representatives. The President is to be elected to a 4-year term together with the Vice President without re-election. Rights of suffrage by male citizens of the Philippines who are 21 years of age or over and are able to read and write. Extension of the right of suffrage to women within 2 years after the adoption of the Constitution, the Bill of Rights, which is the most crucial here, and then the territory by which the Philippines claim. So to conclude my report, the 1935 Constitution provided the legal basis of the Commonwealth Government, which was considered a transition government before the granting of the Philippine independence with American-inspired Constitution. The Philippine government would eventually pattern its government system after American government. And it has also been said that the 1935 Philippine Constitution was the best written Philippine charter ever.
Article 7 Executive Department. Section 1 stated that the executive power of the government is on the hand of the President. That only means the executive department is assigned to the President. In Section 2, therein mentioned that the elected President and Vice President, whose votes are the highest during the election, shall sit on the position for 6 years. However, if the votes are equal, the members of the National Assembly will vote and break the tie. And Section 3 stated that only natural-born citizen of the Philippines, a qualified voter, 40 years of age or more, and lived in the country for 10 years, shall be qualified to be elected as the President or Vice President. In Section 4, the President and Vice President are not allowed to be re-elected for the following term. And Section 5 stated that the election for President and Vice President are held every 6 years. In Section 6, it is stated that the terms of the President and Vice President shall end soon on the 30th day of December following the expiration of 6 years after their election, and the terms of their successors shall begin from such time. In Section 7, it is stated that if the elected President died or failed to qualify, the Vice President shall take the position of the President until the President shall have qualified. In Section 8, it is stated that before the President shall take the position, the President shall take the following oath: I do solemnly swear that I will faithfully and conscientiously fulfill my duties as President of the Philippines, preserve and defend its Constitution, execute its laws, do justice to every man, and consecrate myself to the service of the nation. So help me God. In Section 9, it is stated that the Congress shall, by law, provide who shall serve as President in case of death, permanent disability, or resignation of the acting President. He shall serve until the President or the Vice President shall have been elected and qualified, and be subject to the same restrictions of powers and disqualifications as the acting presidents. In Section 10, it is stated that the President shall have an official residence and shall not receive within that period in any other emolument from the government. In Section 11, it is stated that number 1, the President shall have control of all the executive departments. 2. The President shall be the Commander-in-Chief of all armed forces of the Philippines. And 3. The President shall nominate and, with the consent of the Commission on Appointment of the National Assembly, shall appoint the heads of the executive departments and bureaus officers of the Army from the rank of Colonel, of the Navy and Air Forces from the rank of a Captain or Commander, and all other officers of the Government whose appointments are not herein otherwise provided for, and those whom he may be authorized by law to appoint. But the National Assembly may by law vest the appointment of inferior officers in the President alone, in the courts, or in the heads of departments. Number 4. The President shall have the power to make appointments during the recess of National Assembly, but such appointment shall be effective only until approval by the Commission on Appointments, or until the next adjournment of the National Assembly. 5. The President shall from time to time give to the National Assembly information of the state of the nation and recommend to its consideration such measures as shall judge necessary and expedient. Number 6. The President shall have the power to grant reprieves, commutations, and pardons, and remit fines and forfeitures after conviction for all offenses, except in cases of impeachment upon such conditions, and with such restrictions and limitations as he may deem proper to impose. He shall have the power to grant amnesty with the concurrence of the National Assembly. Number 7. The President shall have the power, with the concurrence of a majority of all members of the National Assembly, to make treaties, and with the consent of Commission of Appointments, he shall appoint ambassadors, other public ministers and consuls. He shall receive ambassadors and other ministers duly accredited to the Government of the Philippines. Lastly, in Section 12, it is stated that number 1, the executive departments of the present Government of the Philippine Islands shall continue as now authorized by law until the National Assembly shall provide otherwise. Number 2, the heads of the department and chiefs of bureaus or offices and their assistants shall not, during their continuance in office, engage in the practice of any profession or intervene directly or indirectly in the management or control of any private enterprise which in any way be affected by the functions of their office. Nor shall they directly or indirectly be financially interested in any contact with government or any subdivision or instrumentality thereof. Number 3. The President may appoint the Vice President as the member of his cabinet and also as the head of an executive department. That's all.
Good morning, I'm Crystal Jane C. Martinez, and I'm going to start my report. So, Article 8, Judicial Department. Judiciary, also known as the judicial system or court system, is the system of courts that interprets and applies the law in the name of the state. The judiciary also provides a mechanism for the resolution of disputes. Under the doctrine of the separation of powers, the judiciary generally does not make the law. However, it enforces the law, which is the responsibility of the executive. But rather, it interprets laws and applies it to the facts of each case. This branch of the state is often tasked with ensuring equal justice under the law. It usually consists of a court of final appeal called the Supreme Court together with the lower courts. So, this law states that the judicial power shall be vested in one Supreme Court and in such inferior courts as may be established by law. The next one is the Article 9, which is the impeachment. So the impeachment, Section 2, Article 9 of the Constitution says that the President, Vice President, members of the Supreme Court, members of constitutional commissions, and ombudsman may be removed from office via impeachment. Only one complaint can be filed against an impeachable official per year. If an impeachment complaint does not prosper, a second complaint cannot be filed within the same year. So, the President, the Vice President, the Justices of the Supreme Court, and the Auditor General shall be removed from office on an impeachment for any conviction of violation of the Constitution, treason, bribery, or other high crimes. So, the next one is the Article 10, which is the General Auditing Office. The Commission on Audit, abbreviated as COA, is an independent constitutional commission established by the Constitution of the Philippines. It has the primary function to examine, audit, and settle all accounts and expenditures of the funds and properties of the Philippine government. So it states that there shall be a General Auditing Office under the direction and control of an Auditor General, who shall hold office for a term for 10 years and may not be reappointed. The Auditor General shall be appointed by the President with the consent of the Commission on Appointments, and shall receive an annual compensation to be fixed by law, which shall not be diminished during his continuance in office, until the Congress shall provide otherwise. The Auditor General shall receive an annual compensation of 12,000 pesos. So the next one is Article 14, which is the general provisions. The state may not be sued without its consent. The armed forces of the Philippines may be composed of a citizen armed force, which shall undergo military training and serve as may provided by law. It shall keep a regular force necessary for the security of the state. So, it states that the flag of the Philippines shall be red, white, and blue with a sun and 3 stars as consecrated and honored by the people and recognized by law. And all public officers and members of the armed forces shall take an oath to support and defend the Constitution. And the Congress shall take steps toward the development and adoption of a common national language based on one existing native language until otherwise provided by law, which is the English and Spanish, shall continue as official language. And the state shall promote a scientific research and inventions, arts and letters shall be undergo its patronage. The exclusive right to writings and inventions shall be secured to authors and inventors for a limited period of time. So the next one is the Article 18, which is the Commonwealth and the Republic. It states that upon the final and complete withdrawal of the sovereignty of the United States and the proclamation of Philippine independence, the Commonwealth of the Philippines shall henceforth be known as the Republic of the Philippines. So, the government established by this constitution shall be known as the Commonwealth of the Philippines. And it states that the Philippines is under on democracy. That's it. Thank you.